Good morning, everybody. My name is Lorna Rigby and I'm a Senior Associate in the Employment Team at Napsons. Ordinarily, I work out the Liverpool office, and today I am actually in rainy Liverpool to present the first of our 5 in 5 series. Now, today we're going to be looking at redundancy and how to carry out a fair redundancy. I'm going to go through the slides that I've put together, and then rather than it just being a bit of a death by PowerPoint session, we're going to come on to the live question and answers. Now, we're going to do those at the end, so if you have a question, you can just type question into the text box, and then my colleague Stacey will unmute your mic and then ask you to ask the question. If there's any problems with that, you can then type it out, and Stacey will read out the questions and I will answer them at the end. So hopefully that is okay. If you have any disturbances such as doorbells, children in the background, don't worry about that. We're here, we understand the circumstances in which everyone is operating. So when we come to the questions, if there's anything that we can't answer straight away, or there's anything that's particularly needs a bit of tailoring, we will follow up with you because we do have email addresses. But obviously we're hopeful that we can cover those off today. The first thing I should mention is we're here today to talk about a fair redundancy. Now, I will touch upon collective redundancies, but we're not going to spend too much time on that. And when I say collective, I'm talking about where you're making 20 or more employees redundant in a period of 90 days. So as I say, I will mention it, but we won't go into too much detail because that is a topic in its own right, as it were. So looking at what we're going to cover today, we're going to have a look at, in the introduction, why does it matter that we do a fair redundancy as employers? What is a redundancy situation? And we'll also touch upon furlough, and obviously the CJRS scheme that was introduced by the government, which is applicable until the end of October this year. The importance of checking policies before you get to making any redundancies. And then we're going to look at the key ingredients of a fair redundancy. So it's whether there is a genuine redundancy situation, and then we look at consultation and consideration of questions about redundancy, and then we'll move on to our live question and answer.
Hello, sorry about that. I think Lorna may have just lost signal, but we'll just give her a few moments to rejoin the chat. Do apologise for this.
slide off, slip back.
For those who have just joined, our speaker Lorna is just having a few connection issues, but she's just trying to reconnect to the Zoom meeting now. So hopefully there shouldn't be too much of a disturbance. We'll just have to bear with us a moment while we try to get Lorna reconnected. So Lorna's back now, so we're just going to take a few minutes just to set up the slides again on the screen for you.
So I think we are back.
Yep, thank you, Lorna.
Right.
I can hear you okay now.
I apologise. I really, really hope this doesn't happen again, and I appreciate your patience on this. So what we were talking about before I was rudely interrupted by technology was why does a fair redundancy matter? So we've got the stability of the workforce of those left behind, and obviously the business itself. An employer, you know, if it can avoid it, doesn't really want to be making redundancies for its reputation, not only perhaps to competitors, but also to potential future employees. And then we've got productivity and employee morale. Obviously, if employees are constantly looking over their shoulder, thinking that they could be next, that's going to impact on the work that they actually perform for the business. But I think if you have got talented employees in the workforce who you're really keen to keep, there's the concern that they do have that talent and that they can walk. So you want to try and create that stability for them. I think perhaps longer term as well is also the risk of employment tribunal claims that you might have as a result of making redundancies. Now, if you follow a fair process and you have a fair redundancy, the likelihood is you will defend the claim. However, there is obviously the management time involved and the cost of defending tribunal claims. The most likely claim that you're going to get is a claim of unfair dismissal. And what I should mention is employees need to have 2 years or more service to bring a claim of ordinary unfair dismissal. There are some exceptions to that. Now, obviously, if an employee says that they were selected for redundancy because they've blown the whistle or asserted a statutory right, they don't need any length of service to bring those claims. So you might find yourself facing claims from those who have 2 years service, but also those who don't. Equally, in terms of discrimination claims, people don't need a particular length of service to be able to bring those. And the way that might be relevant is an employee saying that it was an act of disability discrimination to be selected for redundancy based on their disability, or it might well be in relation to maternity, something like that. They're the obvious discrimination claims that we see in redundancy situations. And I guess as well as the financial cost, if you are to instruct lawyers to defend those claims, there's the cost for the business as well in terms of time. So we can obviously assist you through the process if you are ever facing those tribunal claims, but we can't get in the witness stand for you. We will still need your input in terms of the witness statements, and you'll still need to turn up at tribunal and give that evidence on the witness stand. We can't do that bit for you. So in an ideal scenario, you would avoid claims altogether. Now, obviously, you will have people who always want their day in court, always want to bring a claim. If we know we followed a robust procedure, we will be able to defend that claim, but we may even be able to get it struck out at an early stage. If we're confident that the claim has been brought vexatiously, we can apply for those strikeouts. And just a point as well, in terms of tribunal claims, they do appear now on the tribunal's judgment website. So even if the claim is settled or withdrawn, it does appear the name of the employer. Equally, so does the name of the employee as well. But that is just something to bear in mind. In terms of what is a redundancy situation, it can sound, I suppose, quite basic, and we're going to touch upon the legal definition of redundancy a bit later on. But essentially, the notion of redundancy is when an employer decides to reduce the number of employees it has in its workforce, whether that's by site or business unit, or just the number of employees per se. And just set out on the slide, we've got some of the reasons why an employer might decide to make a redundancy. Now, I suppose the classic examples are, when you lose a customer, it might well be that you don't have as much business and therefore you need fewer employees to carry out that work. And that's obviously been the case recently. It might well be that you've got new technology, which means you need fewer employees to actually do the work, and you've got technological advances, which mean you can do it. It might be relocation, and then, practically we advise clients all the time, and one of the things we're often asked is, well, I need to get this person out, and what is the best way of doing that? And we'll touch upon that later on in terms of, how you go about exiting someone, and is it always wrong to call it a redundancy situation? But that is commonly what we're asked. The first point before we even get on to consultation or anything like that is have a look what you've got in terms of policies. Now, it's unusual for us to see contracts of employment or redundancy policies which set out exactly how you need to make a redundancy. That said, probably a hangover from some public sector is where you've got enhanced entitlements on redundancy. So you need to have a look at that. And it might well be that there's nothing written down, but there's been a custom and practice of paying employees in redundancy situations an enhanced package. So that's really relevant before you even kind of put pen to paper in terms of the rationale. It's to look, what will entitlements be in terms of redundancy payments? But also, is there any set protocol in place as to how we need to handle this redundancy? And the most obvious one is selection criteria. So it may well be that selection criteria has been agreed in the past with the union, that that's the way we do it. That's obviously not always best for the employer because things change over time, and what might be relevant for your selection matrix 5 years ago is not necessarily going to be the same now. The reason it's important is you may have policies and they might not be contractual, in which case you're not going to face any penalty as such for breaching those. It'll just form part and parcel of whether the redundancy was fair. However, if those policies are contractual, you're then in a situation where not only might you be facing an unfair dismissal claim, but you also might be facing a breach of contract claim as well. So what we don't want is those things to come out the woodwork much later on when we're in a process of consultation. We want to know at the outset what we're dealing with. Is there any contractual policies or procedures that we need to bear in mind? Are there any policies or procedures where there's a question mark as to whether they're contractual and we fear we might have that challenge? So that's why looking at those is important. We'll be going through today the key ingredients of a fair redundancy process. So as I flagged at the beginning, I think there's 4 main ones. Is there a genuine redundancy situation? Because it's only if there is, you will establish your fair reason for dismissal. And the reason that's relevant is if you're facing an ordinary unfair dismissal claim, an employer has to show 1 of 5 reasons to be a potentially fair reason for dismissal. That doesn't mean that if you show 1 of those, it is a fair dismissal. then the question is, has it been treated as a sufficient reason for dismissal in those particular circumstances? And that will factor in procedures and what you followed as well. However, if you don't fall into a genuine redundancy situation, you may well have fell at the first hurdle, in which case you don't have the opportunity to go on to the next stage. And just for those, just to recap, the reasons are capability, conduct, redundancy, statutory illegality, so that would be perhaps if an employee doesn't have the right to work in the UK, you can no longer employ them, and some other substantial reason, which is what some restructures rather than redundancies can sometimes fall into. And then, has a fair selection process been applied in a fair way? Selection is a really important part, and to be fair, it's probably the most contested issue that we see in redundancy dismissals. And has a consultation taken place with at-risk employees? And the consultation must be meaningful, which we'll talk about a little later. And have we looked at suitable alternatives to redundancy? So they're the key ingredients, as it were, when we're looking at individual redundancies. So the first point then is the redundancy situation. The law sets out when there is a redundancy situation. And in summary, it's in one of three ways. So it's where a business has decided it's closing, we're going all together, it's no longer trading. That is quite a clear example of a redundancy situation. Where perhaps one particular site is closing, again, that is a redundancy situation. And then the third, which tends to cause employers the most headache really, is where there's a reduced requirement for employees to do work of a particular kind. And I think this is where employers tend to struggle a little bit, seeing whether what they're suggesting they do does fall into whether there's a reduced requirement for employees to do work of a particular kind. So a couple of classic examples. Obviously, if you're introducing technology and you've got the same amount of work, but your machines will now do 50% of the work and your employees will do 50% of the work, that is a reduced requirement for employees to do work of a particular kind. Equally, if you lose a customer and you need 8 people to make widgets as opposed to 10, then again, you've got a reduced requirement for employees to do work of a particular kind because you're going from 10 to 8. Where it tends to get perhaps a little grey, but is still a redundancy situation, is where you're thinking, well, I'm not necessarily sure there's a reduction in work, but I want to strip out a layer of management. So I don't need that middle layer of managers. I've got my top and I've got my junior staff, but I don't need that middle. The likelihood is that is going to result in a reduction and therefore a redundancy situation, because you will have reduced employees to do that work of a particular kind. Now, where that could cause you a potential headache is when we get to selection. Some of the things to think about is, will there be a reduction in numbers? The likelihood is, if there is a reduction in numbers and there is a genuine redundancy situation, and it's not you're trying to get somebody out just based on performance who you then intend to replace with somebody else, there will be a redundancy situation. Will you replace, and where is the work going? It might well be that you've decided you no longer want employees to do that work and you want to use external suppliers. Obviously, TUPE is a potential concern there. It won't always be a TUPE situation, and when it's not a TUPE situation, the likelihood is it will be a redundancy situation. One thing I would say is employers tend to focus very much on cost savings, and absolutely, if you are making changes to make cost savings, then that is a feature that you should consider in your business rationale, which we'll come on to. You know, if you've lost 20% of your business, if you have a requirement to lose X% of your workforce, then that should be documented. However, it's not up to the tribunal to tell you how to run your business. And if actually your balance sheet is looking pretty healthy and everything's fine, but you think, I need to make some efficiencies here just for the good of the business, that is still okay. It doesn't have to result in needing to save money to be a redundancy situation. What I would say is, where you've got situations where perhaps it isn't the case that you need to save money, the rationale is going to be scrutinised. As I say, the tribunal can't say you should have done something differently. They can't substitute their own view. They can say a particular way you've done something is outside the bands of reasonable responses, and that's the difference. So the business rationale, so when clients come to me, and often, something will have happened which means they need to make changes quickly. They need to save costs quickly. And everybody wants to go headlong into it, because you say to people, well, 1 week, 2 weeks, potentially up to a month. If you're looking at collective consultation, it's even longer. Employers tend to get fixated on this. Right, okay, we need to make the change now. We need the change to be in effect by X. Let's get the people who we need to get at risk. And I completely understand that. One of the things that will help you is putting together a business rationale. And I often call it the golden thread. If you put together a rationale that's clearly thought through and sets out why you're proposing to make the changes you are and what has driven that, that will be your golden thread, which can be the detail for each of your consultation letters and your rationale. And the benefit of doing it like that, rather than just putting something in a letter, is that it keeps that credibility. So if you are ever challenged, you can look, well, what was the rationale? That stayed the same in all the redundancy consultation letters. And we've got that credibility. We're not slightly changing the reasons every time we do a consultation letter. That's not to say if you don't have it, or if you do slightly change the reasons, it will necessarily be an unfair dismissal, but it certainly gets you set out on the right track. And I think the more errors, the more issues that tend to arise, makes the tribunal more wary as to whether this is a genuine and credible redundancy situation. So what should be included? Generally, employers will set out the background, what has led them to putting together this rationale. Why has the situation come about? So obviously, most recently, it's been COVID-19 and the impact that's had on businesses. What the business has considered to avoid redundancies. Now, a tribunal will never say, as it were, you shouldn't have done this or you shouldn't have done that. But if you've recruited somebody into a similar role that you're then going to make redundant, the question mark will be, well, you must have known about this situation when you offered that position to that new employee. Did you think about retracting the offer? Have you thought about cutting overtime? Have you thought about asking employees to reduce their hours? Now, it might not be that would work for your business, and a tribunal can't say you should have done that. But what they will be looking at is what was considered to avoid redundancies. And often, being truthful, employers do still go through the redundancies, but it is important to try and address that. And that will also help with your consultation with the employees as well. What the proposal is, and note the word proposal. So often we're asked to look at these rationale documents, and it will be a case of perhaps tweaking them, giving advice on them, and very often they come across as a done deal. This is what the business is going to do. This is the person that's going to be made redundant, or this role is the role that's going to be made redundant. It's all a proposal, and the reason it's a proposal is because the changes are subject to consultation. In the main part, generally individual consultation with the employees. And then effectively what impact the change will have on the business when the proposal is introduced, if it indeed is. So that's why the rationale is important in getting that right and setting out why you're thinking of doing what you are doing. And what I would say is, if you do face a tribunal claim, in all likelihood, this is going to be a disclosable document. So just bear that in mind and give it the thought and attention that it needs. One of the questions we were asked back probably March, April, May time is, what about the CJRS scheme? Can I still make redundancies? Does it go against the purpose of the scheme? Do I have to put everybody on furlough? The answer we gave is no, you don't. If you still need to make redundancies, then absolutely you can do. There's nothing that precludes that in any of the guidance or Treasury directions that we've seen. That said, it will be a factor, in my view, to be considered if you do face an unfair dismissal claim. So we're having a lot of employees saying, well, why don't you just put me on furlough? And then if at the end of it there's a redundancy situation, I'll take that, you know, I understand. What we've said is there might be reasons why you're not using furlough. What you need to show is that you've considered it. What you don't want to happen is the first time you're explaining, you know, why you didn't consider furlough in the witness stand. We don't want that. We want you to have considered that before. And again, it'll only be largely applicable to those employees who have 2 years or more service who can bring that ordinary unfair dismissal claim. So it's likely to be a relevant factor in any tribunal claim. That said, moving forward, now, because employers from the 1st of August will have to contribute to the furlough scheme in terms of pension contributions and national insurance, and then from the 1st of September, they'll have to pay 10% of the 80% furlough pay, and then from 1st of October, 20% of the 80%. It's less likely to be as impactful on the employer. I think it was probably more relevant when putting people on furlough was effectively cost neutral for the employer. But it is something that should be factored in. Equally, Rishi Sunak's announcement on their plans for jobs, this bonus that an employee will get for keeping an employee employed between November and January, £1,000 per employee who has been furloughed and then brought back. I think it's probably fair to say that, you know, that £1,000 wouldn't be enough to suggest why we should. Again, it's something to bear in mind. Another question that we were asked about furlough was, can I use the furlough pay to pay employees' notice pay? And we've said, yes, you can. There's certain circumstances where you'd have to top up the notice pay by 20%, so the employee got 100%. But as long as they're working out their notice, albeit on furlough, then there's no reason why you can't claim. Now, what it's pretty clear you can't claim for is payments in lieu, which used to be quite popular with employers because it gets the employee off the book straight away, and their obligations in terms of looking for alternative employment can end at that stage. You can't claim for redundancy payments either. So in terms of the selection, as I mentioned before, this is one of the key points and key contested points, selection for redundancy. When you're putting together your business rationale, you need to decide which roles will be affected. Now, if you lose a customer, then it's up to the business effectively to say where they think they need to lose roles, if they need to make cost savings. Obviously, the most naturally impacted role would be relevant in the first place. So if you've got a customer who no longer needs as many widgets, it would be the people making the widgets that you would imagine would be mostly affected. But it may well be other areas of the business as well. Now, there's no set law as to how you need to do it in these circumstances. Reasonableness factors very, very heavily. But if you've got a situation where clearly 2 employees aren't doing the same role and you only then choose one to put in the selection pool, it is likely that a tribunal would say that that was outside the band of reasonable responses. Where it's a little bit grey, you need to be looking at those arguments. And one of the key questions we're often asked is about pools of one, or whether the pool should be wider. Now, commercially, employers will generally prefer a narrower pool because it has less impact on those other employees who we're saying at that stage don't need to be in the pool. Legally, sometimes it's safer where there is similarity of skills to widen that pool. Realistically, we're looking at a pool of one where we have a reduced requirement for that particular job role, and it's only that employee who does that job role. There have been cases where there's been territory managers in various parts of the UK, and there's been a drop-off in work in one area. An employer has managed to show it was reasonable just to focus on that area that dropped off. That said, where there's transferability of skills and employees are effectively doing the same job, that will be a case where you probably need to widen the pool. There is a different way you can approach it, which is not commonly discussed, I would say, which we'll touch upon in a second, where you've got perhaps a unique job role, but not necessarily just that employee doing those particular tasks. And like I've mentioned on the slide, it's not necessarily what the job title is. That is absolutely the starting point, as long as the job title reflects what the employee does. Where it can cause difficulty is where an employee isn't really doing the tasks of that job title and is doing something different. So key questions to consider: what type of work is ceasing or diminishing? The extent to which employees are doing similar work, and the extent to which jobs are interchangeable rather. So where employees are very much doing two jobs, then obviously it's a case of widening the pool. If an employee is sometimes perhaps covering for another employee in a different department through sickness or absence, that's not necessarily the case where you would need to widen the pool. If it's on those very sporadic occasions, they're not doing it regularly, there would be an argument there that you don't need to widen the pool. And whether employees are doing similar work at other locations. Now, we talked about site closure earlier on. If you've got employees, at different ends of the country, that's not to say that you need to put both sites in the pool if you're only losing one. Where employees have come unstuck in the past in case law is where there's two sites in very close proximity and employees are doing very similar work, and perhaps where there is that interchangeability between sites, where people are moving between sites, that's obviously going to be that risk there by not widening the pool. Where they're quite discrete and separate, if there's a decent geographical stretch in between them, then there's certainly an argument that you don't need to widen the pool. Where they're close, it becomes a little more tricky. So identifying the selection pool, one of the things that we've seen employers do is actually say to the employee, do you believe we've got the selection right? Now, obviously that can be a bit of a double-edged sword, because if they say yes, it's a great tick for you. If they say no, you've almost prompted them to kind of engage in dialogue about that. When I mentioned before about commencing the process as a pool of one, often we'll get employers, so an example I had was, there was a supervisor and a team member, and the supervisor was doing some supervisory skills, and the employer needed to lose a role out of the structure, and the manager could do the locking up and the opening up, which was what the supervisor was doing. The supervisor couldn't do the rest of the manager's role, so we didn't think we had a situation where we needed to bring the manager in. However, the supervisor was doing a lot of the daily tasks, probably 70% of what a junior employee was doing. So when I talked before about pool of one, it's not always the case that you have to say pool of one, we stick to it rigidly. What we did in this situation is we commenced the process as a pool of one. So we explained that we had a reduced requirement for the supervisor role and we needed to save costs. However, we recognised that they did some duties of the junior team member. That said, we couldn't afford the salary of the supervisor. And what we said to them is, look, if you want to be pooled for the more junior role, you can be. Very often what you find is employees don't want to be. They don't want to take that step down. But that is a helpful way sometimes of dealing with the situation where there is potentially a pool of one, but perhaps some question mark. And if they say absolutely not, I don't want to be pooled with that junior role, then you've got that tick in your consultation minutes. What I would say is that's a bit different to when you have a vacancy. When we're looking at suitable alternative employment, in that case, it should actually be offered, we shouldn't just ask about it, and we'll touch upon that a bit later on. Make sure you document your reason. Part of the issue why an employee will often fall down in a tribunal claim is the first time they're asked these probing questions is when we're trying to defend, not at the beginning. So the way you've done it is so.
Hi everyone, sorry to interrupt, Lorna. I think you may be having some connection difficulties again. I'm struggling to hear you through my session. I'm not sure if it's the same for everyone else. So I'm not sure if you maybe want to disconnect and reconnect again. Is everyone else having the same problem as Lorna froze? Yeah. Okay, it seems other people are having the same problem, so I'll just pick up with Lorna and ask her to disconnect and reconnect to the session. I think she's just having some connection difficulties, so I do apologise, but please bear with us a few moments. Thanks everyone for your patience. Lorna's just trying to reconnect now, so she should be back with us shortly. Thanks for bearing with us, everyone. I think Lorna's just having a little bit of a difficulty rejoining the meeting. If any of you do have another meeting or anything to get to, and you need to leave the seminar early, we'll be making the slides and a recording of the session available, just in case you do need to leave early. But I'll just pick up with Lorna now and see if she's okay with joining us again. Hopefully it shouldn't take longer than another 5 minutes or so. Thanks everyone for bearing with us. Looks like Lorna's back with us. Lorna, I think you're still muted at the moment. I'll just unmute you now.
Right, thank you for that, Stacey.
No problem.
Right, just get back to it. I'm really hoping that won't happen again. I've now changed network connection, so I'm hoping we're going to be perfect from here on in. So, where were we? We were talking about when we've got our pool, we then need to make the selection criteria. And again, this is one of the areas that tends to be really, really contested. So this is when we've got our pool, we know we need to go from 20 to 10. We don't need a selection matrix where we have got a pool of 1 because it's effectively a self-selecting role. Where we've got our 20 going down to 10 or 10 going down to 5, whatever it may be, we have to look at putting together a matrix. So the selection must be one that a reasonable employer acting reasonably could have made. So again, we've got our feature on reasonableness. Now, there's this big question about should I have objective or subjective criteria? And I think perhaps a few years ago, there was a big focus on it's got to be objective. And what I mean by that is something that can be really measured without any real opinion. So whether that be attendance record, disciplinary record, qualifications, you can't argue if someone has a particular qualification like a degree, or punctuality. So they're kind of like the 4 really, really objective criteria. Where you'll often face a claim from an employee is where the criteria is very subjective. So their manager, who they'll probably allege has a gripe against them, has scored them, and it's not really justifiable as to why they've given the score they have. Now, there's a case on there, and what that effectively said is the notion of having subjective criteria isn't a dirty word. We can have subjective. My advice would always be to have a mix of both. The reason we can't just rely on objective criteria is disciplinary record, punctuality, attendance, that type of issue. People might score the same. You might be able to give them 5 marks for each, and then how do you make the decision? And is that really going to be picking the best people for the business who you need moving forward? Arguably, no. So what we'd recommend is having those objective criteria in there, but also having subjective ones as well. A couple of things to flag up is it's not necessarily having subjective criteria that's wrong. It's being clear about what we mean by that and how we score it. And the use of a matrix, so we often see a matrix that has maybe 10 or 15 different criteria in there, and it can get quite complicated. And being completely frank, it can cause issues with the scoring as well. There is, I suppose, a benefit of having 10 or 15 criteria in there, and it might well be that it cancels out perhaps some of the subjective ones because you've got so many categories to score. You've got that 10 or 15. My advice would be to keep it simple. Maybe have 6, something like that. And those points are going to be key for what you need in the business moving forward. So keep it simple. A lot of employers will often ask about weighting as well. Should they apply a particular weighting to something they see is really important? Again, because we're dealing with reasonableness, there's no set rules. What I would say is that if the criterion that you're weighting as, say, 50% and the other 2 you're weighting as 25%, if that's the score that somebody would do poorly on, and they're the one who's going to say, but that's because, you know, I have this gripe, they have this gripe against me, it could look particularly targeted. So that is my only concern in terms of weighting, particularly when we've only got a few criteria. One of the key things is you put together these matrices, and we do it quite a lot, and then we look, and you've got to think about, does it work? Have you explained it clearly enough for a manager to be able to understand how to score? Do the scores work? Some of the potential selection criteria that we have, so we've got disciplinary record. The thing to point out on here, sometimes an employer will consider expired warnings, which is probably just about defensible, but it's not ideal. Obviously, if it's an active warning, that can be taken into account. And it may well be that, you know, somebody will get 5 for a clean record, 3 for a warning, and maybe 2 for a final written warning. Absence, punctuality. The thing you've got to factor in on absence and punctuality is any absence that may be occasioned by a disability. So if somebody has something and it affects them and they've taken those absences, that could be disability related absence. Similarly with punctuality. Similarly with any leave that's been taken for parental reasons as well. What we have seen is cases where, you know, employees on maternity leave have been given the maximum score, and that's not always the right way about it. What you should try and do is not necessarily skew the figures, but maybe take into consideration a different period. And when we're looking at attendance, we tend to say, you know, it's probably best not to do anything less than a year, perhaps 2 years if possible. There's always the question about, well, what if someone's broke their leg? What if someone's lost a family member? You know, is it a bit mean to include that in? Well, not necessarily, because I think the issue you have if you start saying, well, you know, they lost somebody close to them, they had a broken leg, is you start making value judgments about whose absence is more important. Now, obviously, you've got no choice when it comes to parental leave or paternity or maternity leave, or indeed disability related absences. But other than that, you know, it's certainly defensible not to include the reasons why those absences may have occurred. Qualifications and skills, as I say, qualifications can be quite easily measured. Skills probably a little bit more subjective. Productivity, that's something which you could measure, and costs to the business. You need to be a little bit careful, and I certainly wouldn't be suggesting that you use costs to the business as the sole issue, because you then might face a claim of age discrimination, because those who are paid the higher salaries may be the older ones in the business. There is, of course, the argument that you can objectively justify it. So there's no problem in having it as part of the mix, but don't have it just alone. And then experience is one that we see quite a lot. In terms of attitude, flexibility and potential, they are very, very subjective, and you could see how a manager who might not like an employee would perhaps use that as an opportunity to explain why they should get a lower score. One of the things I would say is you can have these in there. There has been a case just on attitude which said it was nebulous and vague. But sometimes it's the way an employer chooses to score that and chooses to comment. In a selection matrix, you have the opportunity in the comments box to explain and give examples. And the real importance is that it's done properly with those examples, and that the person scoring has been able to turn their mind and articulate exactly why they've given the score they have. In truth, what you don't want it to be is really vague and really unclear, and an employee doesn't understand why they've been scored how they have. Be clear, give detail, give examples. And also give it time as well. This is often the case. What we see is really rush through selection criteria. Well, I have to score them. You put the effort in, put the time in. That is somebody's job. Length of service, that used to be really, really popular. There's a risk now it could discriminate on grounds of age if you use that as the only factor as to determining who should go. So years ago, it used to be last in, first out. Now that's not generally used as a sole criterion because of the potential risks on discrimination. Largely age, but could also be sex and race as well, because females will tend to have more time out of the workplace to raise a family, so built up that length of service. It's often used as a tiebreaker, and that's okay. They're the potential ones you can have. Obviously, you have to pick the ones that you think fit your business. Now, what I would say is you can have those subjective ones, but make sure you explain what you mean by those. Don't be nebulous, don't be vague. Make it clear what the employee needs to show to get those particular marks. Considerations when scoring. We've touched upon this. You need to provide that justification for giving a score, which can be relied upon later. And it's more difficult to justify subjective criteria, but by no means impossible. And at the end of the day, you need to run your business as you see fit. Yes, we can help you and guide you to get to a reasonable dismissal, but ultimately you need to pick those employees who will be able to give your business the best service. Ideally, you want more than one person to conduct the scoring. So that could be one person who does the scoring and one person acts as a moderator. It might well be two managers will independently score. And it should really be the line manager who does that, who has the most experience of that employee to be able to score. The reason why it's good to have two people is an employee might allege that one employee who is scoring them has a particular gripe against them, so that maybe grievances are raised, etc. So that's why you want that strength in depth of another scorer or moderator. We're often asked, we can't really put together a selection matrix that works. Can I just do an interview? Well, where you've got like 20 going to 10 or 9 going to 5, whatever, selection matrix is the fairest way. So you can have that objective and subjective criteria. An employee will often say, well, can I have an interview as well? Yes, you absolutely can have an interview as well. As I say, there's no hard and fast rules. You get a bit more ability to be more subjective when you're recruiting for a new role. So it might be everybody role in the structure is going. So all managers are going, and we're now having supervisors who have or will have a different skill set. You get an ability there to be a bit more subjective and to have that interview process. Moving on to consultation. What I would say about consultation is selection is probably the biggest issue. Consultation is also a big issue, and what you've got to think about is it's not a rush job. You're not trying to get from 0 to 100 as quickly as you can. It's got to be meaningful, it's got to be two-way, and you've got to listen to the employee. And so consultation, if you don't have it, it's almost always unfair. You've got to give them meaningful information as well. It's no point giving them vague assertions, tell them the facts, tell them the stats, give them the information to be able to respond, and don't expect them to respond on the spot, as it were. Now, you'll sometimes have employees who don't have anything to offer, but it's important that it's pushed. And my preference, rather than a kind of pro forma consultation document, is minutes. So ask the employee if you've got any thoughts. We know this is a difficult time. Handle it with a bit of compassion. I think there's often this issue with employees want to know as quickly as possible, and employers are conscious of doing a fair process, so not rushing it. And I think there is a balance to be had. And if employees ask questions, what we should be saying is, well, it's subject to consultation, but if we do decide to go down that route, this will be the result. So you don't lose that flexibility for consultation. And you know what, if the employee has a good idea, think about it. If it works, great. If it doesn't, tell them why it doesn't work. Don't just say can't be accommodated by the business, because you'll need to explain it at some point, and better that you do it then, because it might actually result in you not getting a claim. As I mentioned, one of the things that we see quite often is an employer will go through this process but haven't really done it in spirit. So they've done it in form but not in spirit, so they haven't really engaged with it because they just see it as a means to an end. So it's really important that it's done thoroughly and properly. And then what we said is do not rush consultation. There's no hard and fast rules in terms of like how long it should last if we're not dealing with a collective consultation situation. So we're just dealing with our 19 or fewer employees. We would generally say have 2 to 3 meetings, particularly 3 when we're looking at scoring and taking detailed notes. So where you've got a pool of 1, the absolute bare minimum is a week, and that's come from case law. When selecting from a wider pool, the absolute minimum is 2 weeks. Now, I'd say that's quite tight. If you can, give yourself a month. I appreciate that might not always work and might not be best for the business, but if you know you need this change in the future, start early. It's one of the key things that an employer will be asked. When did you warn? When did you consult? When did you know about it? And just in terms of selection as well, if you have got unions, it's important to share that selection criteria with the unions as well. So in terms of a process, how I would generally recommend it is that if we're dealing with a pool of 1, we have a heads up meeting, which is very, very brief, and we just explain our potential rationale. We give them a letter inviting them to a first consultation meeting, and then they have that first consultation meeting. We use our letters properly as well, so that our letters aren't just invites to the next consultation meeting. What we can use that letter where we invite them to the next consultation meeting, meeting 2. And as I say, I'd have a heads up, I'd have a first consultation meeting, and I'd have a second. What we can use that letter for is to tell them which points they raised and why we're not agreeable to it. So we can almost cover off the redundancy situation in that letter. And we have that second meeting and we say, look, we've listened to your concerns about the redundancy. Unfortunately, there's no steps that can be taken now. But before we go on to considering whether you are leaving the business or whether there's any alternatives, let's have a further discussion. So it might well be in that meeting we move on to the alternatives. So we want 2 or 3 meetings and we've got our timescales there. It's a little bit different when we've got selection, because what I'd recommend is that you share the blank selection matrix with the employees to listen to see whether they've got any comments on it. So this is before we even score them. We talk about the selection pool with them. We talk about the potential redundancy situation. We share the blank selection matrix. We ask them whether they've got any comments on it when they've had a chance to look at it properly. And they might say no, in which case we move on to scoring. We then send the meeting, before the meeting rather, we send the scored selection criteria to them so they can feed back in the meeting about their scores. And then at the third meeting, that tends to be the mop-up session, assuming that there's no alternative employment that we can offer, and assuming that there's nothing else that's come out. That will generally be, after that third meeting, we will confirm that they've been selected for redundancy and we will issue notice. Now, what I would say is we can start off with having these time scales, and it might be great, you know, if we get it through in that time, but just be prepared, because we need to see what comes up in the consultation and what points are raised. Now, we're often asked, do we need to offer a right of appeal? If they've got 2 years or more service, then absolutely, it's a key to a fair process. The ACAS code doesn't deal with redundancies, but it would still be fair practice to offer that appeal. And it's certainly something that we would recommend. And if the employee, we've gone through a fair process and we've listened to the concerns, the likelihood is they might not appeal. It's only if they've got the bit between the teeth or they think that the process hasn't been handled particularly well, are they more likely to appeal. What do I need to consult about? So the reason for the proposed redundancies, the selection, the scores, and alternative employment. And it's always good to have an independent note taker in there from the business so that the person making the redundancies isn't focused on taking the notes as well. How do I consult with employees on furlough? Well, we could use Zoom. Hopefully it would work a little bit better than it has today. We can send emails to them. We can have those redundancy consultation meetings. There is nothing to stop you having those just because they're furloughed, so they're still allowed to engage in a redundancy process. You might want to record the meeting if the employee agrees. Often we're seeing, so one of my clients is actually allowing them to be accompanied by a family member rather than just their statutory right of a trade union representative or a fellow employee. There's an argument as to whether the right to be accompanied truly applies in a redundancy situation, but again, as a matter of good practice, we would say that it does, particularly where they're going to be confirmed as redundant. You don't have to allow a family member because a fellow employee could join Zoom just the same, but they are quite uncertain terms, and we have had those requests. As I say, there's not a one-size-fits-all approach. When is collective consultation required? Well, as I mentioned, I'm not going to go into too much detail about this, but it's a statutory duty when 20 or more employees are going to be dismissed as redundant within 90 days. So if you're looking at those types of figures, you need to think about the collective redundancy process. It's 30 days if 20 or more, but less than 145 days if 100 or more. And as mentioned on the slide, it's the total time for consultation, not just discussion with the employees or trade union representatives. The consultation doesn't have to last the 30 or 45 days, but the first dismissal cannot take effect in this period. And taking effect is either if you pay them in lieu the date when they're confirmed as dismissed in the last working day, or if they're given notice, the date of expiry of that notice. Collective consultation. So as well as individual consultation, if you're dealing with 20 or more, you will be required to consult with trade union representatives if you have a trade union recognised for that category of employees who are at risk of redundancy. If you don't have a trade union, then you might have employee representatives already in place. Now, they have to be appropriate for that particular exercise, the potential redundancy exercise. If there aren't any in place, then you need to go through a process where you elect representatives unless you're a micro employer having less than 10 employees. So for the main part, you will need to invite employees to elect employee representatives, and that can take a bit of time in itself. And so you need to consult about certain things when we're dealing with a collective situation. You'll also be required to issue a HR1 to the government. And if you get collective consultation wrong and you fail to collectively consult where you should have collectively consulted, when you're making 20 or more employees in 90 days redundant at one establishment, if you don't do that, you've got a risk of up to 13 weeks pay, and it's gross pay per each employee affected. So it's quite big numbers. It doesn't, collective redundancy doesn't, and collective consultation rather, doesn't replace individual consultation. You can do them in parallel. In an ideal world, you do collective first and then individual because it's clearer, but you can do them in parallel if you are pushed for that time. Moving on then to, you've done your consultation, you know you've got your fair redundancy situation. You're thinking, but for any alternatives, you will be made redundant. That role is going. And what we need to be thinking about here is there any alternative to them leaving the business? So yes, their role as supervisor is redundant. But is there an alternative to them leaving service? We're obliged, and part of the test for a fair dismissal in an unfair dismissal claim is, have we considered suitable alternative employment? There's two parts to the test about suitable alternative employment. It's a key factor to consider, not only to avoid an unfair dismissal claim, but also in terms of a redundancy payment as well. So in terms of what makes a suitable job suitable, this is where we look objectively at the employee's job that they're leaving or made redundant from and the job that we can offer. And we need to look at this objectively. What's the salary differential, if there is one? What's the seniority? Loss of status is actually quite a big thing. So if you say, well, I'll pay you the same, but you're now demoted to perhaps office junior, that's not necessarily going to be a suitable job. What are the skills required for both of them? So if it means that their skills will deteriorate, that might not be suitable. And then obviously the hours and the location. And what we often say is, you know, this is an internal employee at risk. If you then recruit an external candidate for that role, you could potentially face an unfair dismissal claim. If your redundant employee could never do that vacancy that you've recruited somebody external for in a month of Sundays, it'd take them perhaps 4 years to get a degree or whatever it may be, then you're not going to have an unfair dismissal claim there. If there's more room for argument that this employee could move into that role and have the training and be ready to do it within a couple of weeks, then you're much more likely to have the argument. And how hard must you say it? You've got to put some effort in, basically. You don't need to create a job, but you need to take reasonable steps. And we're often seeing employers just sending sheaves of vacancies to employees. That's not actually enough. If we find a couple of roles that we really think are suitable alternatives, the employee has to actually be offered them. Now, if you have 5 people at risk of redundancy and you only have 2 roles, of course you can operate some kind of process, whether that be competitive interview. But if you only have 1 vacancy and 1 employee who's at risk of redundancy, and they could do that role, it needs to be offered to them. And when does the search finish? Up to the point of dismissal, including the notice period, not usually after dismissal. A point about women on maternity leave. So if the employee on maternity leave is in a pool of 5 and she is selected for redundancy, so she's one of the 3 selected for redundancy, there's nothing wrong with that. She doesn't get special dispensation not to be selected for redundancy. What she does get special dispensation for is if then, after she's been selected for redundancy, there are other vacancies that is a suitable alternative. So if you have 5 and you need to go down to 2, and our person on maternity leave is one of the 3 selected for redundancy, she then trumps the other 2 who are also at risk because she's been on maternity leave. There was discussion from the government that was going to be extended to 6 months after the return from maternity leave, but that's not in force as yet. But currently you do need to do that whilst an employee is on maternity leave. Is there a suitable alternative role? So the first step is it a suitable alternative? And that's judged primarily objectively, looking, you know, side by side at the 2 roles. If there is a suitable alternative role, the next question is, has the employee acted reasonably or unreasonably in refusing that role? If the employee has acted unreasonably, they lose their right to a redundancy payment. Now, what I would say is this is quite a tricky test for an employer. Don't be too quick to assume refusal is unreasonable. The refusal is considered from the employee's point of view. So if on the face of it, it looks a great role, but the employee can't source childcare for it, then it might not be unreasonable for her to refuse it. In truth, we have quite few employers who are trying to kind of do an employee out of their redundancy payment. But it is something certainly to bear in mind that you do have that argument if we believe an employee is unreasonably refused an offer of suitable alternative employment. And as mentioned before, an employee does have to have those 2 years service to get a statutory redundancy payment. So a few top tips: err on the side of caution. Don't assume that the employee won't be interested in something. Let them decide. Keep an open dialogue. You know, it might well be the employee just accepts it and works for a couple of months and then moves on. That's okay. They're allowed to do that. And be willing to train the employee. explain to them the impact of refusing a suitable alternative role, which we've touched upon. And as I say, those at risk, bear in mind that the employee has to be offered the role, not just invited to apply. If you're then going to run the argument that they've foregone their redundancy payment or foregone the right to the redundancy payment. Equally, if you're facing an unfair dismissal claim, if you say to the employer, do you think you'd be interested? And they say no. And then later down the line, we're in a situation where, oh, what did you do with that role? We want to be clear that we're constantly saying to them, is that something that you would be interested in? We can offer that to you, offer it to them, and then they may well refuse. And one of the most important things is keep good notes, because tribunals being as they are at the moment, they're listing cases far, far into the future. And it's really important that we have that decent paper trail if we are facing a claim. A few top 5 redundancy myths or frequently asked questions. People often say, well, it doesn't matter about a fair process because they have less than 2 years service, so they have no rights. They can't claim ordinary unfair dismissal, that's correct. However, those who do have less than 2 years service can claim for discrimination if they believe that there's been an unlawful act on one of the protected grounds. If you've not really got much by way of a credible argument or a paper trail, it can open up the question as, well, what was the real reason for dismissal in this case? So in an ideal world, if you're dealing with employees who do have 2 years service, I would treat them all the same. Unless you've got a pool of one with less than 2 years service, it might be you decide to take a quicker route, but I would still follow some process, and that is to avoid a claimant lawyer filling the void and saying, well, this is obviously the reason for dismissal. We often get asked, well, let's just call it redundancy because it's kinder. Well, that's not great, because if that reason is seen through at a tribunal and the tribunal finds it wasn't a redundancy situation, we've lost our 1 of 5 reasons. What we do often get asked is an employee will come to us and say, I've got this employee, he or she is absolutely rubbish, I need to get rid of them. And then we'll probe a little bit into the detail. Well, yeah, obviously, if you've got 2 years service, you go through a series of warnings on grounds of their performance. And they say, not even sure I actually need them in the business anymore. Well, what are you doing? Are you planning to replace them? Well, no, I just actually don't need that role. That then starts to take on a bit more of a complexion of, actually, is it redundancy? Is the main or principal reason for the dismissal redundancy as opposed to performance? And that's something that, you know, we can certainly help with. If you're intending on getting someone through the back door, you know, the next week after they've gone to do exactly the same role, then it's not likely to be redundancy. And realistically, the only way that you're going to do that is by starting a performance process and perhaps doing a settlement agreement. You always have to have objective criteria. Well, no, you don't. You should have some, but you can have subjective criteria as well. People often say, oh, it's just a box ticking exercise, we just need to go through the motions. That's completely untrue. I've had cases where on paper an employer has done things right, technically, but when you look at the selection matrix, it's literally scrolled in scores. There's no explanation as to how they've got the scores. They score performance, and then there's no real explanation as to why that employee has scored what they have for performance. There's no performance PDP or anything that sits behind it. It looks like it's been done at a rate of knots. So they followed it in form, but not in spirit. Make sure that you follow it in spirit as well, and do your planning. The earlier you can warn and consult, all the better. And then I can't make an employee redundant on long-term sick or maternity. Well, you absolutely can. There's no reason why they can't be made redundant. They might have PHI cover, which is something to consider. If they don't have that, then if there is a redundancy, you can obviously go down the route of making them redundant. Now, there might be other factors we need to consider as to why they're off. You know, is the potential disability claim there that we need to consider? But it's not, you know, no, we can't do them, we can't touch them, we can't do anything to them. That's absolutely not the case. Understand the reason for needing to propose redundancies. Identify the affected roles. Ensure there's a fair selection criteria applied fairly. And remember, consultation is not just a box ticking exercise, it should be meaningful. and consider all alternatives. And don't forget those left behind. You remember I touched on this earlier in the slides. So you've done your redundancies, you've gone through it, you've had no appeals, you're feeling proud, but it's the rest of the workforce, the survivors as they're called. Have a communication plan with them. They will be feeling unsettled by the change. They might be looking around and thinking, what if I'm next? The change doesn't stop on leaving day. Think about how you talk to them. And then there's some point about allow for an emotional response. They might have extra workloads. Listen to them, try and build trust, because the last thing you want to do is go through all the hassle of making redundancies and then the people who you've kept leave as well, and then you're then into a recruitment situation. So really, I think it's about being honest and building trust. And one of the things I would say is when you are doing these redundancy exercises, do obviously keep an eye on the legal aspects to make sure that you have that fair redundancy, but think about the human aspect as well. And it's sometimes that causes the most issue. Employee not feeling valued, employee feeling that they don't have a say, that it's rushed through. One of the key cases there was a while ago was there's so many errors in the process. An employee said the consultation had been rushed. He had 40 years service and the employer spelt his name wrong on the consultation letters. And it's just that attention to detail, you know, just watch that. Everyone's busy, just put the effort in that you really can. So I hope that has been helpful. And now we'll move on to our questions, if that's okay.
Yep, hi Lorna. We've had one question so far in the chat box. This is from Michael. Michael doesn't have a microphone, so I'm going to read his question out for him. So he has asked, if an employee is being made redundant and we offer them an alternative job in the business on the same terms and conditions, does the employee still have the right to be made redundant?
That is coming back to our question about, is it a suitable alternative? So if their existing role is going, there will still be a redundancy situation. However, they may forfeit their right to a redundancy payment if they have that right, if they unreasonably refuse. So we've got that objective test that we talked about before, and then we've got the subjective element as to how that new job applies to their particular circumstances. If actually we believe they have unreasonably refused it, then we wouldn't pay the redundancy payment. That employee could then pursue a claim to the tribunal, which if we chose to defend it, we'd fight about whether the job was a suitable alternative and whether they reasonably or unreasonably refused. If the employee won, they'd be awarded the redundancy payment. If they lost, they wouldn't be.
Thank you, Lorna. So we don't have any more questions in the chat box at the moment. So I'd just like to remind everyone, if you do have a question, please could you type the word question into the chat box and I'll be able to come to you and unmute your microphone. So I'm not sure if I want to just give it a minute or so just to see if anyone does have any questions, and then we can address those.
If anyone asks about the IT, honestly, it's not my fault. Yeah, we'll just give it a couple of minutes. If you do think of anything that's you know, pops into your brain later on, then by all means do ask us and we will come back to you. Do we have any more, Stacey?
No more have come through yet, so I think if no one has any questions, we can end the meeting here. And as you said, if anyone does have any questions, they can pick those up with us after the meeting if they want to. Yeah, absolutely. Well, thank you very much for joining me today for our first 5 in 5. Apologies again for the technology, and we will make sure that that is sorted next time. And thank you for bearing with me. I hope that's been helpful. Thanks, everyone.